Alex here with part 186 of the My Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the ex parte motion for a temporary suspension of my ex's in-person visitation rights. And I know I've talked about this before a number of times in the series, and even though this gets granted, it's not the way that you think it gets granted. In fact, the way that this ex parte motion gets dealt with exposes some of the serious biases and flaws of the court system generally and this specific district court judge. Though I need to really be clear, I'm not going to say that I think all of the family court judges would have done the same thing that she did, but I am going to say that I think most of them would have. You are going to see a train wreck of mistakes that she corrects on her own, and the more interesting, I guess, discussion will be on the way in which she does it. Because to me, it comes off very much as a sort of CYA, cover your ass approach. And I'm not going to get yellow flagged for that, I don't think. Guys, if you, sometimes you'll hear me say that on these videos. Sometimes, depending on the language used in the videos, YouTube will yellow flag a video. What it does is it makes it so hardly anyone sees it. It's like 1/10 of the number of people see those videos because they get flagged as controversial. So they're not stricken, they're not erased, they're not blocked. It's just they like kind of funnel them into another track of viewers, and it's frustrating when that happens because I want to maximize how many people see these videos. Anyway, I think that this is going to be, no, I could go into my mindset. I remember being really frustrated. I remember being really frustrated because I continued to ask my ex what her address was, and she refused to answer. And in fact, you guys have seen at least twice now a message where she said she doesn't have to tell me where she lives anymore now that she lost custody of the child. So she just cooked up a new excuse as to why she doesn't have to say where she lives. And at the same time, these things are going to come to a head because she asks to see him. She asked me to fly him over to her in Reno without telling me where they're going to be. I think that she does maybe let me know which hotel she's going to stay in. I can't remember now. That might come up in my ex parte motion. But in any event, I remember insisting, this hotel thing isn't good enough. You do have to let me know where you guys actually live. And it was especially curious because I don't think she even gave me all the details of the hotel. I think she just gave me the specific hotel. I might be getting ahead of myself. We might go through the ex parte motion and she really doesn't tell me anything. It's totally possible that that's the case. In any event, I remember being really frustrated. I kind of felt like she was becoming unglued. Her appearances at the school and at the appointments were so bad. And with all of these things going on, I really put my foot down and I said, you need to tell me where you live. This is required. And I used the Supreme Court case. You guys saw me file a motion for continuing duty to disclose, where I used my Falcone v. Secretary of State, which is the case named after me. I used that. And then in this ex parte motion, I think I do the same thing. I'm not quite, I'm not fully sure. But I do remember being really frustrated. I remember having a lot of anxiety because I didn't know if the judge was going to screw up on this issue. And spoiler alert, she screws up. Now, luckily, she fixes her own screw up a few days later, but that didn't really help. I mean, it's still, my confidence in the court system is still shattered. My confidence in this new judge is wishy-washy. I mean, sometimes she's great and other times she's worse than Judge Weller. And so it's like, I think one of the things that's most anxiety inducing for us as protective parents is that we don't know what these judges are going to do. They're so unpredictable. What's really frustrating is that they think we're unpredictable. And we frustrate them because we don't do things the way that they want us to do them. But they don't realize that they themselves, to us, are also unpredictable. And in some ways, completely random. In any event, I'm going to end up talking a whole lot more about this when we actually get to the orders entered on, not just this motion, but the other motions, because they end up getting intertwined. And so, all that being said, let's go ahead and take a look at what I have filed. go into the ex parte motion for temporary suspension of visitation, I'm introducing myself to the court as the petitioner, that I'm appearing in proper person, which means I don't have an attorney, and that I'm asking for ex parte relief. If you guys want to know more about why I am not a fan of ex parte motions, please watch my video on the topic ex parte perils. I don't think that I've ever gotten an ex parte motion granted even once, which is really frustrating because I have seen other situations where people have attorneys and they get them all the time. So it makes me feel like non-attorneys, no, you don't get ex parte relief, but if you're an attorney, you do. I lump that into self-representation bias if you want to take a look at that. There's also the issue of discretion. Take a look at the video of discretion, because that's another area where most of these biases bleed through, and that also explains why sometimes the judge will grant something for somebody with a lawyer or for a different type of person, and with other types of cases the judge won't do that. And then there's also the situation of different districts. So like in some districts, ex parte motions not really popular, most of the judges deny them. In other districts, it's the opposite. The judges just give them out to anyone who asks almost. I've noticed all kinds of weird things when it comes to these types of motions. If you don't know what an ex parte motion is, it's a motion where you're asking the court to make a ruling without the other person's input. That's what you're asking. And there's, as far as I know, 2 types of these. The most common type is the secret motion, which is just a motion where literally you don't let the other person even see it. You send it up to the court looks at it, and the only thing that in second judicial district court that they would get is a request for submission. They'd see something like a request for submission, but they wouldn't see the actual motion itself that would get hand delivered to the court maybe, or something like that. The other type is not the secret one, but you need immediate relief, and you need relief so fast that even shortening time, there's no time for even that. So with an ex parte motion to shorten time, you're filing a normal motion, but you're asking the court to order the other side to respond very quickly. But with this type of ex parte motion, you're saying, this isn't secret, I don't mind if they see this, I'm going to send a copy to them, but I need relief right now. We're not going to wait for them to respond. You need to answer right now. And so that's the type of ex parte motion that we're doing here. The rules are not exactly 100% clear on what I just explained, but you can sort of read between the lines and come to that conclusion, at least when it comes to the Washoe County District Court rules. If I remember correctly, they sort of discuss those 2 different types of ex parte motions. And when it comes to giving notice on the not secret but emergency motion like this, they do have some special things put in there, like they expect you to call the other attorney on the phone. They expect you to maybe fax it to them or email it to them. They expect you to go above and beyond and notice them because of the nature of your request. Anyway, these are all the things that I can recall in the general sense. You should of course take a look at the video ex parte perils to get some more details. Scrolling down, we have my summary here. We share a common minor child of age 9. I have primary physical custody with reasonable visitation rights to my ex. We share joint legal custody. We communicate through our family wizard. I've posted my address into the info bank, and my ex has refused to do so. Factual background. We have December 3rd, 2015, the omnibus motion to establish a continuing duty to disclose a physical residence that I filed. In that motion, I indicate that my ex has demonstrated an extreme level of recalcitrance on the issue, or is that recalcitrance? Probably recalcitrance on the issue, and has employed a combination of measures to avoid revealing her physical address. The factual background at 2A describes in detail the background of the case regarding this issue. Next, we have my ex's attorney's filing of a motion to withdraw as counsel of record, and in that motion, he uses his client's inability to communicate. Next, we have my message to my ex detailing the manner in which we should coordinate and communicate regarding visitation. At this point, I've become concerned because she's not logged into our family wizard in over a month. Even prior to this, she began to show a disturbing trend where she would log in only to send a message, but never read and respond to any messages that had been sent to her. To date, she has 30 messages that she has not even opened up and viewed. On December 25th, 2015, she sent a message indicating she'd purchased a ticket for him to have flown to her the next day to commence her visitation. She did not read or respond to any of the other pending messages. On the same day, I responded that the flight was scheduled in conflict with the instructions in my previous message and requested that she post her physical address in the info bank. On the same day, she responded with an alternative that was still in conflict and continued to refuse to disclose her physical address. On December 26th, I informed my ex that because they were at an impasse, that I would file an ex parte motion with the court on the following Monday. On the same date, my ex responded by disclosing the address of a hotel. On December 27th, I made multiple flight or she made multiple flight changes but continued to fail to disclose her physical address. On the same date, I reiterated. On the same date, she responded. On the same date, I clarified. On the same date, she responded. On the same date, I reiterated. So you guys are going to go through all of this nonsensical communication when we get to exhibits 8, 9, 10, 11, 12, and 13. Legal analysis. Parents have a right to know where their child resides. For the 15th time, I'm trying to tell everyone, hello, the Supreme Court has spoken. Joint custodians have an obligation to share with each other where they live. Admonishments do little to curtail my ex's conduct because my ex knows full well that she cannot be held in contempt of court. Though the motion is currently pending on continuing order to disclose physical addresses, the instant demand to exercise visitation without disclosing her physical address presents a serious safety issue. Should something happen to our son, I would have no idea where to even send the authorities to conduct a welfare check. Our child's mental health professional has even expressed alarm upon the realization that I do not know where my... I'm getting mad as I read this because I know what the court's going to say. And it just, it's the position that these judges take is absolutely indefensible. They make the most inane determinations on the most obvious issues. It's like, can we please not exchange at midnight? No, you need to exchange at midnight. It's like, can you please let her know to tell me where she lives? No, no, she doesn't have to. She can just like live in secret places and tell you where she's going to spend the time in the hotel. As I go through these, I start to feel my blood boil because I can remember what it felt like at the time to have your child's to have your child's fate in the hands of these incompetent jurists. So we're going to get to the order denying this ex parte motion, and you're going to basically see why I am so livid with this judge. Again, she fixes her own screw up 3 or 4 days later, but we'll talk about that when we actually get to that document as well. There's a lot of stuff that's going to come from this particular portion of the motion practice before the court. Preliminary injunction, of course, that's something that's not available to non-attorneys. A little bit of cynicism there for me. A preliminary injunction is available when the moving party can demonstrate that the non-moving party's conduct, if allowed to continue, will cause irreparable harm for which compensatory relief is inadequate. This goes into the irreparable harm. I guess you could call it a doctrine or definition or whatever. I talk about this more in the video injunctions. Definitely take a look at that so you can learn about it. But I'm trying to get an injunction here, which is pretty standard. Attorneys ask for it all the time. Non-attorneys, I think it weirds the court out when you ask for it because you're not supposed to know how it is or what it works or how it works or what it is. Pursuant to local rule 43 sub 1A and B. By the way, I don't edit those things out because I think it just shows how even my brain gets scrambled when I go through these videos. Anyway, pursuant to WDCR 43 sub 1A and B, I have given my ex special notice via email. The scope of the injunction is very narrow in that it only seeks to enjoin her from exercising visitation until she discloses her physical address into the infobank of Family Wizard. Perfectly reasonable request. And I can't help but feel like there's some gender bias here. Because the idea of a mother living in secret, I guess some people can see why. But imagine a father refusing to tell the mother where he lives. I mean, everyone will be up in arms. And for a judge to say that, hey, you need to give your child over to a father who won't tell you where she lives, like, I guess that would start angry mobs, at the courthouse. But when the vice versa occurs, I guess it's just not a big deal and the father should be punished. So if you guys want to know more about why this happens, please watch my video on the topic gender bias. Rule 65 sub B1 is satisfied because our child would suffer irreparable harm if injured, detained, abandoned, incapacitated, and I wasn't aware of where he resided. Rule 65 sub B2 is satisfied by the numerous emails which were sent to my ex regarding the issue. The Supreme Court has established a precedent regarding temporary restraining orders in family court cases, and there's 2 or 3 different cases here where they have used temporary restraining orders. This is not the type of restraining order that you guys are thinking of, where you think of it's like, a domestic violence type of thing. It's different. I think I have a video on the topic titled Temporary Restraining Orders. Definitely take a look at that video because it's not what you think. It's the prelude to a preliminary injunction. It's different. I'm not exploiting this dispute to deprive my ex of her visitation. I am sincerely concerned for the child's welfare. I propose that the court award my ex substitute visitation after the dispute is resolved. Rule WDFCR 43 sub 3B. Should the matter... Okay, yeah, so if the court does enter this temporary restraining order, the court should set a hearing within 10 days of the date of that order, which is required by the local rules. Rule 5 certificate of service indicating this document was mailed to my ex's attorney and that a copy was emailed to him. Here is the motion opposition notice. This is a document that indicates that I did not have to pay a $25 filing fee to file this motion. And then we have the list of exhibits. We have a total of 14 exhibits that we will go through. Exhibit 1. So this is from me to my ex. In the future, keep in mind that his holiday visit starts on or after 5 p.m. Thanksgiving visit turned out okay because we had no plans, and my wife was able to get him to the airport. I can be understanding if, for example, if you find a cheaper flight at an earlier time on one of your days. But if you're going to do that in the future, you need to coordinate with us. For example, this upcoming winter break visitation would not be a good time to set an earlier flight because he's going to be on a birthday party on that day. I also do recognize that last Thanksgiving visit you said you would arrange the flight if it wasn't good timing. What I'm encouraging is a better alternative to that method because you don't have to lose money by doing flight changes that could be avoided by communication and coordination. The only thing I can imagine here is that she probably just scheduled a flight without giving me any notice or without giving me enough notice, something like that. Exhibit 2. These are all the messages that she hasn't opened. That's what I'm assuming. Yeah. Exhibit 3. My ex says to me, I wasn't able to afford a ticket until this week. Many of the flights are booked, but if this doesn't work, she can try to reschedule it. Exhibit 4. I clearly stated that all Army had is a birthday party on the 26th, and you'd be required to follow the court's orders and boundaries. The flight is too early, so it doesn't work. The court's orders also require that you let me know where you are taking him when on vacation. Even if you aren't taking him anywhere, it's absolutely critical that you upload your address into the info bank. This needs to be the address that you reside at, not a mailing address, friend's address, or some other irrelevant location. A residential address would be the address you generally live, eat, and sleep at. I'll not be putting him on a plane if you don't comply with this requirement. I mean, it's only been like 2 or 3 years since the Supreme Court has spoken on this issue. It's like, I mean, the Supreme Court said so. I mean, moving on. Skip Exhibit 5. The latest flight available, this is from my ex to me. The latest flight available leaves at 1. Everything after that is still full, except for the very late flight leaving around 10 at night, which is too late. From my ex to me. Read message, haven't responded. If the 1 p.m. flight sells out, then his ticket will still be for 10:40 a.m. You need to respond if you want me to change it. This is interesting here. So she's looking to my messages, and she can, I don't know if this is true. This might be a lie. But she's saying that I read her message and didn't respond, which is interesting because that would mean that she knows she has 30 messages pending that she just hasn't read. So it's such a strange, I really think that this is less manipulative and more mental health. Like at this point in time, it seems to me like she's legitimately unable to address anything but this very narrow situation that's before us. Weird. So next we have, what was this? Another dog. From her to me. So you are insisting that he fly late at night past his bedtime, and you want me to schedule the flight for this one? I'll reschedule unless you tell me the time that doesn't work in the next hour. If you don't have a flight to come up with some reason you aren't going to send him, you've already got all the information required. So basically what might have happened here is that she just might not be telling me where she lives. And so I'm just ignoring her messages. It's possible. I can't recall, but eventually she does get a response. And then here we have my ex saying his flight is now. And then she has this other date and time and all this other information. Exhibit 6. Here we have my response. There's a motion pending on the issue. Because we have reached an impasse and the motion will not be resolved in time, I will prepare and file an emergency request to suspend your visitation. And this is for not giving the address. Exhibit 7. She says, I don't have the right to refuse to send him. Well, I will when the judge enters that order. She says that she'll be staying at the Nugget. They have an indoor pool. She's given the Nugget location. So it's interesting that she waits until after the motion is filed to even tell me the hotel. Like, I mean, this would have been a good idea to say, it still wouldn't have satisfied me, but it would have at least been a good idea to send the location of the hotel before all that other shenanigans, while all the other shenanigans and communications over the flight were going on. Exhibit 8. Now she's rescheduling again. It's like all this money she's throwing down a hole. And it's just unfathomable. If you already know we're at an impasse, why do you keep scheduling flights? Weird. Okay, so she's saying that the flight is rescheduled. She says that I need to tell her. I already told her that she's not going to get to see him. This has already occurred. There's a limit on the number of times she can reschedule before she loses the flight. She can't refund it. Okay, so maybe she's not losing money. She just keeps rescheduling. And I guess she's not losing any money, something like that. I already told her that she's not going to get to see him. I already filed an ex parte motion. Everything's already pending, but she's just pretending that none of this stuff exists. And again, guys, all she would have had to do was give her address up, which is what the Supreme Court told her to do. Moving into the next section. Hurting him by not letting him spend time with her. Okay, this is common. They try and guilt trip you. Again, she's hurting him by not giving the address up. If she would have given the address up, she would have been able to see him. This is what she has to do to continue the conflict. She knows she can't give me the address because if she gave me the address, the conflict would end. I've talked about this before. This is the outcome that she wanted. She wanted to be deprived of visitation. She wanted to be this mom that wasn't allowed to see her child because of an evil dad. And for these things to occur, she had to do certain things to force this outcome. If she would have just did what she was supposed to do, which was to give up her residential address, then she knows none of this conflict would have occurred. She would have had the child and then everything would have been fine. That's not what she wants. The goal is not for everything to be fine. The goal is the conflict. That's the point. So she has to refuse to give me what is reasonably required to force me to make this decision so she can get the outcome that she wants. If you want to learn more about this, I don't know if I talk about this. I might talk about it in the video 3 Phases of Conflict, but I don't think that that's necessarily what it is. There are some videos where I talk about the mentality of the high conflict parent. I just can't remember the title of it now. Sorry about that, guys. If anybody remembers, go ahead and mention it down in the comments below and we can talk about it, or I can at least discuss it in my next video. Exhibit 9. So then I just reiterate to her the message that I already sent. And she replies, or then another one from me saying, I told you you would not be taking him. And then I reiterate the other message that I sent. Exhibit 10. She said, so what day will you be sending him? Like, seriously. It's like she has selective memory. I don't understand this at all. Wow. Exhibit 11. You'll find out after the judge makes a decision. Because the physical address issue is in dispute, is a safety issue, it's likely she'll make a quick decision. She may or may not assign makeup days for the time you lost. Exhibit 12. She says there's no safety issues. She's not disputing any address stuff. You know where we're going to be. Again, she's playing dumb. She's saying that the nugget, she isn't even really saying it, but she's acting like I know where they're going to be and that satisfies the issue. But it doesn't satisfy the issue because what's required is a residential address. Exhibit 13. Here she says, oh, this is from me to her. It says, I won't be taking him, see the message sent, and I'm quoting the message sent. So these are just me reiterating messages that I've already sent to her. Exhibit 14. This is me communicating with her attorney. It says that I'm mailing an ex parte motion to suspend her visitation rights, and then I give him an email version of it. And that's it. Next document, request for submission, and this is me submitting the ex parte motion to the court for consideration. As you can see, I didn't wait for an opposition or reply. I submitted it to the court immediately. Going into the aftermath, I filed 2 documents. They were both free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably briefly read these and possibly tried to reach out to her. Unsure about that, though. I think 15 minutes, maybe that's a little light. There are a lot of exhibits in there. I'm going to go ahead and say 30 minutes. 30 minutes at the rate of $250 an hour. That's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.